So we now come to the last part of this part 3, chapter 3, which is insolvency resolution process for individuals and partnership firms. So we start again from section 117 now. Completion of the repayment plan. See, the RP shall within 14 days of the completion of the repayment plan forward to the persons who are bound by the repayment plan, which is basically the creditors and the debtors, and the adjudicating authority, the following. 1. A notice that it's been fully implemented. 2. A copy of the report made by the RP which summarizes the receipts and payments in pursuance of the repayment plan and the extent of implementation of the repayment plan as compared with the repayment plan which was approved by the Committee of Creditors. And then the resolution professional may apply to the adjudicating authority to extend the timeline by maybe another 7 days. So this is actually the conclusion of the process where the RP prepares a report on the completion of the repayment plan. The next section deals with the repayment plan ending prematurely. So 118 of the Act speaks about a premature end to a repayment plan. If it's premature, if it has not been fully implemented in respect of all persons bound by it within the period as implemented in the repayment plan, as specified in the repayment plan. So premature end is actually, see, every repayment plan needs to have a plan of repayment and a period by which it will be implemented. So where it fails on the period ground, then it becomes a premature end. Now, where it's a premature end, the RP shall again submit a report on the premature end, and what will be the contents of those reports, the receipts and payments which have been made in pursuance of the repayment plan, the reasons why it ended prematurely, and the details of the creditors whose claims have not been fully satisfied. The adjudicating authority shall then pass an order on the basis of the report submitted by the RP after satisfying themselves that the repayment plan has not been completely implemented. In this case also, a debtor or a creditor whose claims or a creditor whose claims under repayment have not been fully satisfied can go for a bankruptcy order. So this is the third circumstance where a bankruptcy application for a bankruptcy order can be preferred. 1. Where there was a failure on the application itself, it did not get admitted. 2. Order of an adjudicating authority rejecting a repayment plan. That's the second ground. Third is a premature end to the repayment plan. So this is what they say as 100, 115 and 118. 100 is non-admission of application itself. 115 is where there is a rejection of the resolution plan. And 118 is a premature end. Now, in case of a premature end also, they have to file a copy of this order to the board because it marks an end anyway. Then, we come to the last section, which is the discharge order. On the basis of the repayment plan, the resolution professional will then make an application to the DRT for a discharge order in reference to the debts and the repayment plan mentioned in the repayment plan, and the DRT will pass a discharge order. Now, the repayment plan can provide for an early discharge or discharge on completion of the repayment plan itself. Then, the discharge order shall be forwarded to the board for recording entries mentioned in register specified under section 196. The discharge order does not discharge any other person from this debt. So, this is in short, and of course, everything ends with the code of conduct. It says it shall prescribe, the IP shall adhere to the code of conduct specified in section 208. So what we now finished discussing in so many little videos was the insolvency resolution process for individuals and partnership firms. Now I'm going to attempt to do a quick recap on this. It starts with a debtor making an application with a condition. And some of these matters that I'm talking about are special from an exam perspective, that if it's a partnership, then it shall be signed by a majority of debtors. it shall not be for excluded debts, and you can't have a bankruptcy process or a fresh start process or an insolvency resolution process. And 12 months prior to the date of application, no application for this process shall have been preferred. Then the Act spoke about a creditor application. A creditor application, what was special? A creditor can apply against a partnership debt against one or more of the partners or the firm itself. And creditor application obviously needs to have a little more beef. It has to say the debts owned by the creditor. And most important thing in a creditor application is the 14 days notice versus the 10 days notice under the CIRP process. Then interim moratorium. Interim moratorium gets declared. Only two things happen. Stay of legal proceedings in relation to debts. No new legal proceedings in relation to debts. And if there is an interim moratorium on a firm, it shall be interim moratorium on all the partners as well. 97, RP appointment. Two options. Creditor or debtor can name the RP or not name the RP. If they name the RP, it follows a 7-10 sequence of reference by the DRT to IBBI and IBBI to confirm. Here it is 7-7. You have to remember that. And the second part, if no RP is named in the application, then it goes to 7-10. By a DRT to IBBI and IBBI back to DRT. And then replacement of resolution professional. Debtor or creditor can replace. Again, where it's a debtor, the 7-10, he shall make an application to DRT and the 7-10 process shall apply. If it's a creditor, they have two options. Either, to name a new resolution professional, or they don't name a new resolution professional. In either of the cases, the 7-10 rule shall apply again. Now, the new RP who is appointed, the old RP is expected to cooperate as well as hand over information to the new RP. Then, the RP within 10 days of his appointment has to submit a report on the resolution plan. So, what does this report says? It basically says you can either admit, either he finds the process either to admit the application or to reject the application. And where it is furnished by a creditor, he will require the debtor to prove that the debt has been actually paid. So he will say, you tell me a proof, whether it's an encashment of a check or an electronic transfer or a signed confirmation from the creditor that the debt has been paid. Only if that is there can my application debts be minimized. However, where a debt is registered with an information utility, no go back to the creditor is required. Now, the RP in the course of examination of the application may require any person, debtor or creditor or any other person to provide information. Where he is requested for this, within 7 days, that other person, debtor, creditor or other person, shall furnish the relevant information. Now, the RP shall examine the application, and if he is satisfied that the application conditions under 94 and 95 have been met and the relevant information explanations which have been sought for have been given, then he will approve the application, or he can actually prepare a report rejecting the application. Now, there is one more third option. Now, if you find that this debtor comes under a fresh start process, then he can write a report where he says this may have to go back to fresh start process. In either of the case of application admission or rejection, the reasons shall be recorded. Now, a copy of the report has to be given to the debtor or the creditor and of course to the adjudicating authority. The next section is admission of the application or rejection of the application. Within 14 days of receipt, they have to, here the timeline is not specified. Yeah, it is specified. It is 14 days of the application. They shall admit or reject the application and they shall provide a copy of the report to the debtor or the creditor. As the case may be, to the creditor within 7 days. Everywhere you have to provide a copy to the creditor within 7 days. Once the application gets admitted, the moratorium gets ticked. It's only 3 conditions in this moratorium. Just the same 2 conditions of interim moratorium plus the fact that debtor shall not alienate, transfer or dispose his assets. Now, unlike the FSO process, there is a public notice here. It shall be given 7 days from the date of the order. Claims shall be received within 21 days of the appointment. Within 30 days of the last receipt of claims, he shall prepare a list of creditors. So that's why I said you should remember 7th day, 28th day and the 37th day, which is 30 days from the public notice. He has to prepare the list of creditors, and he shall place the list open, and the repayment plan. During this time, the debtor will make a repayment plan in consultation with the RP on how to restructure the debt, and the RP has to give a report on the resolution plan within 21 days from the last date of submission of claims. Which is why I told you there is a 0, there is a 7th day, there is a 28th day, there is a 37th day, and there is a 49th day from the date of order. So you just have to, it's easier to remember like this. So it's 0, 7, 28, 37 and 49. Then they summon a meeting of the committee of creditors, and the notice is at least 14 days notice versus 7 no incorporate. So within 14 days, and in that meeting, what will he place? He will place the resolution plan, his report on the resolution plan, forms for voting, proxy forms, and a copy of the statement of affairs of the debtor. Then they will conduct the meeting. There will be voting rights which are ascertained. 3 categories of creditors shall not be entitled to, it impacts their voting rights, which is unliquidated amount, associate, or those who do not find a place in the committee of creditors. Then there we speak about rights of the secured creditors in relation to a repayment plan. The key aspects to be remembered is 1. Forfeiture of the right to enforce. 2. If not forfeited, only for voting rights, only entitled for the unsecured portion, with the secured and unsecured portion being treated as separate debts. Then 111 is the approval of the repayment plan by the creditor. Then there has to be a report on the committee of creditors meeting, which will say who all attended, what were the resolutions passed, third, whether the repayment plan was accepted, rejected or modified, and fourth, such other information as may be necessary. Now this report will be given to the debtor, creditor, including those people who didn't come or vote or participate in the vote in the meeting, and 3, to the adjudicating authority. After all this is over, he's got the report, he's got the repayment plan, he's got the report, and he's got the minutes of that meeting and a report of the meeting. He will then go to apply to the adjudicating authority for an order on the repayment plan first. See, there is a 2-phase stage here. One is an order on the repayment plan, and then is a discharge order. So the DRT will pass orders on the repayment plan, including who will supervise and monitor the repayment plan and implementing the repayment plan. Now, if the adjudicating a DRT feels that they need to modify the repayment plan, most important thing is he may ask the RP to reconvene a meeting of the COs, the committee, the creditors. An effect of the order of the adjudicating authority on the repayment plan, it's binding on the debtor, it's binding on all the creditors who are mentioned in the repayment plan. And most importantly, if a repayment plan is not approved, it triggers a possible application for a bankruptcy order, because the DRT says then the creditors are entitled to file for bankruptcy. So there are 3 grounds. One is rejection of application. Second is the rejection of the repayment plan. And the third is, of course, I have not come to it, which is a premature end to a repayment plan. The relevant sections are 100, 115 and 118. Implementation and supervision of the repayment plan is yet another section. Then once the repayment plan is completed, within 14 days, he has to send the report on completion saying that it's completed, and then the copy of the receipts and payments, and they shall not extend the time mentioned for such further period not exceeding 7 days. Now sometimes the repayment plan will come to an end prematurely. That is when if the time has actually within the period as mentioned. So if the time has expired, it's a premature end, right? Because you don't have more time than that. Because if you keep this process open endlessly, nothing's going to get done. So when it comes to a premature end, again the RP has to file a report. What are the reasons for that? The receipts and payments during the period, and the list of creditors who have not been satisfied completely. Now this, and then the adjudicating authority will pass an order on this premature end, and the people whose claims have not been fully satisfied might still want to go for liquidation, correct? So they can go for liquidation. That's your third circumstance under section 118. And a copy of the premature repayment, this order on the premature repayment, will also be furnished with IBBI. Then after completion of everything, the timeline is not given, but I presume all this has to happen within 180 days. So the RP will file to the adjudicating authority for a discharge order, which is an early discharge. The repayment plan, of course, can provide for an early discharge or discharge on completion. Similarly, the discharge order shall be forwarded to the board. So when I apply to the adjudicating authority for a discharge order, that repayment plan will either call for an early discharge or discharge on complete implementation of the repayment plan only. So in either of these circumstances, the discharge order will be furnished, sent to the board. And a discharge order shall not discharge any other person, okay, from the liability in respect of his debt. So this is a summary. So the key timelines are 7/7, 7/10 relation to appointment of an RP, 7 days for public notice, 21 days for claims, 30 days for list of stakeholders, 21 days for repayment plan, 7 days for furnishing information, 14 to 28 days for the committee of creditors meeting following the repayment plan. Then notice will be 14 days. Adjournment of a COC meeting is 7 days. Then finally, I think we move to which other section? The last is, of course, I think that was the last section. Then completion of repayment plan within 14 days of completion, extendable by another 7 days. So this is the entire gamut of the IRP process, part 3, chapter 3. So now we will go to chapter 4 from the next lecture onwards.